Hello everyone. In today's video, I will try to explain you a case, and the judgment has been given by the Honorable Supreme Court, and the case is not somewhere, but directly related to Section 306. What Section 306 says or talks about abatement of suicide. 306 of IPC, abatement of suicide, means you are provoking someone, to commit suicide, that you provoke that person with such level that the another person commit the suicide. So the judgment has been given by Honorable Justice Sanjeev Khanna, Sanjay Kumar, and Honorable Justice KV Viswanathan of Supreme Court. So these were the member in the bench, and as I have already told you that the disputed section here is section 306 that talk about abatement of suicide, and we will see the definition and what is abatement in section 107. Okay, so 107 of IPC talks about abatement and 306 talks about abatement of suicide. Now, what overall Supreme Court said that the provocation which has been given by a person should be at that level, and with that, in that amount, that the other person do not have any control on himself, and after listening the person, whoever the person has been provoked, the another person, he committed the suicide after listening him or her, after listening that person, and it was intolerable, and after hearing that all of those, the person committed suicide. So this was the observation of the Supreme Court in this case, and the Supreme Court said that it is not sufficient that a person said something, and because of that words the other person did the suicide. The amount should be at that level, and in that much of amount that should be sufficient, and that a person who is aware also think that this is the sufficient amount, and after listening it up any person would choose to die. So it should be not in a lighter terms, but it should be grave. The wording should be grave, that the person do not have any option left but to commit suicide. This was the observation of the Supreme Court in this case. And what happened in this case, suppose there was a person whose name was T. So Honorable Justice Sanjeev Khanna, Sanjay Kumar, and KV Viswanathan were involved in this case. Now, what are the facts of this case? On 2nd November 2022 at 7:15 p.m., a person named A filed a complaint or lodge a FIR against BMPS. These are four person. And what was his complaint? What was the complaint of A? That these four killed Z with a stick and fist, and was the Z was the son of A. Okay, so these four person killed Z, and the Z was son of A, and then A goes to the police station and lodge a FIR. Now, why they four people killed Z? Because they came to know that the Z, who is the son of A, and the T, who were the relative, who was the relative of these four, and somewhere someone's daughter, somewhere someone's cousin. So T was living with T was these were the family member of T, and Z, who has been killed, was family member of A. Now they heard that Z and T were in a relationship, and they did not able to digest that because they both were from different religion, and that's why these four kill Z with stick and fist, and this was the complaint of A, which A made. Now, according to the report, two persons were witnessed that incident. The witness S2, and suppose the name of the witness number 1 is S2 and witness number 2 A2. So these two persons were there who saw the incident where B, M, P, S, they all four were beating Z. Now they beated Z in that way that it gave Z grievous injury, grievous hurt, and when he went to the hospital, the Z, when people took him to the hospital, there he died. Now it was the complaint of A that file or lodge the FIR against these four with the section 302 that talks about punishment for murder. But what police stations, what was the opinion of police station, that they lodged the FIR with section 304, that was culpable homicide not amounting to murder. Means it was, they didn't plan that they will kill the A, but somewhere their act, because of their act, the person A died. So that attracts section 304 that talk about culpable homicide not amounting to murder. Okay, now what happened on next day, that is 3 November 2022 at 5 p.m. FIR lodged by V against A, this person who made an FIR on 2nd. So next day a person B made an FIR against the person A. Okay, and what was his allegation? V was the relative of that T. Okay, so V was the relative of T and BMPS, and what was his allegation? That A said something because of which his relative T made the suicide. Now I have read till yet. Now what I am going to do, read a passage and then I will try to make you understand. So it was the allegation of V that the A abetted the suicide of deceased T. Deceased T. Now both has been died, the Z as well as the T. Z died because of the grievous injury given by BMPS when they beated him, and T died because of suicide. And it was the allegation of V who lost the FIR that A abetted the T to commit the suicide, to commit suicide. Now the gravamen of allegation means means सबसे महत्वपूर्ण पॉइंट ऑफ सबसे एलिगेशन का सबसे बड़ा एलिगेशन जो था वो ये था. The gravest allegation was at around 8 a.m. the person A came the person A came and said to T that because of you my son has been died, why don't you commit suicide too? What is the purpose of leaving you? When my son died, why are you living? You must also die. So this is what we say. This is what A said to T, and it was because of he was frustrated, he was anger that because of a relation his son died, and when and because of all those messed up thing, he went and taken out his frustration, said to T, why are you leaving? Why you should also die. Because of you, my son has lost his life. So that's why I don't know that's why, but after that, when T heard these things, it was the allegation of B that T thought that her reputation has been fallen down in society. What the people will judge her. Apart from that, the person to whom she used to like also died. It could be any reason, and C commit the suicide. Now, this is the allegation of B that A provoked T to commit suicide, and that will fall as as an abatement abatement of suicide, which is mentioned in section 306 that talk about abatement of suicide. So we file a complaint and FIR against A. After that, we I can also see that the hospital did the postmortem of T, and the doctor said that the reason report of the postmortem was saying that T died because of asthesia. Asthesia, that is suffocation. दम घुटना, फांसी लगाते हैं अगर और दम घुटता है, that is asthesia because of lack of oxygen. So this was the postmortem report of T, in which it was mentioned that she died uh, because of not the other reason, not any other reason, but because of the asthesia, that is because that occurred maybe because of the hanging hanging and doing and committing the suicide by hanging. So when we file the FIR against A, so then the proceeding starts in trial court, and trial court send the summon to the A, and A approached to High Court and says that A approached the High Court using section 482 of CRPC, that is a miscellaneous application, and with that it was the request of the person A to quash the FIR, and the reason was given in that application that no ingredient of section 306 are present here. So basically he wanted to say that the person didn't abet the suicide of that person, the deceased T, and there are no sufficient ingredient that says that the person T, the deceased D, die because of that person. So he was basically denying the fact that the act was abated, and that's why section 306 of IPC will not be attracted. So it would be the request to the honorable court to quash the FIR. Now what High Court did, High Court dismissed the application which was made under section 482. Sorry if I said 382, it was 482, by holding the fact that it is somewhere related with the another act in which the person A, in which the person Z died. So We can't say, the court said, we can't say T didn't die because of the abatement. The court is not sure, and the court can see both the case and both the incident are related with each other. So there would be a chance that the abatement had been taken place or has been taken place. So we are not quashing the we are quashing the current application and not the FIR, because it is somewhere related with the uh, incident in which Z died, and it can be possibilities that T died because of Z. And by seeing those things, High Court denied to quash the FIR made by V against A. The High Court also observed that the deceased T was a hypersensitive girl, and she was very much depressed and felt humiliated among her family members, friends, and in the society. So it was the observation of the High Court that the girl was sensitive, and there could be a chance that the person whoever said to the deceased T, it affected the T, and because of which she committed the suicide. And that's why Supreme Court, by seeing these things, these points, so High Court denied the rejection of the quashing of the FIR that made against A. And then what happened? Then A approached to the Supreme Court. So especially petition was filed against the judgment of High Court, and the Supreme Court accept that appeal. And Supreme Court agreeing with A appellant. Here it is the name of the person, we are assuming A. And in Supreme Court, when A goes, Supreme Court accept his application. Apart from that, Supreme Court shows his agreement with A and quash the FIR and the trial, in which the trial was going against A, and which was saying that the A abetted T to commit suicide. Now, what is the operative part in this case? What Supreme Court said or observed? We find none of the ingredients required in law to make out a case under Section 306 IPC to be even remotely mentioned in the charge sheet or are being borne out from the material on record. So, Supreme Court said we are unable to find the ingredients that will be required for attracting section 306. So we are not finding out that ingredient, and whatever ingredient we have, that is not sufficient. The utterance attributed to the appellant, assuming it to be true, cannot be said to be of such a nature as to leave the deceased Anu with no other alternative but to put an end to her life. And this is what Supreme Court said. Whatever the appellant uttered to disease T, that is not sufficient, and that the person T do not have any other option left but to commit suicide. and whatever the complaint has been made, it is only on the basis of suspicion, one sided, partial, and amicable investigation. And under these circumstances, proceeding with the trial against the appellant in the charge sheet as filed will be a gross abuse of process. As pointed out earlier, the case has several disturbing features which call for a reinvestigation. Apart from that, court also says that the court can observe a lack of investigation, so they want that the investigation re should be done once again with the additional perspective, with including additional perspective. Apart from that, Supreme Court also ordered that a special investigation team should be conducted, and it should be headed by at least DGP, that is Director General of Police, to investigate the unnatural death of T, and find out what was the reason of T of dying, because it was not the natural death, it was unnatural death. So a team must be conducted that should be headed by at least Deputy Director General of Police. Apart from that, they also gave the liberty to file an FIR once again, because here Supreme Court is quashing the older FIR that was made by V against A, and because Supreme Court said that the ingredients are not sufficient for attracting Section 306, and the case is only based on Section 306, and that is not sufficient. So we are giving an additional opportunity to looking out into the matter, and find out find out how the person T died, because uh, and the person can also file the FIR once again. The court also said, we direct that the investigation report shall be placed before this court in a sealed cover within a period of 2 months from today. And if you want to read out the case, this is the name of the case, that is Ayub and others, Ayub and others versus state of UP and another another criminal appeal number 461 of 2025. So this was the name of the case, and this was the fact that I personally tried to understand. Apart from that, you heard me, and of course you have already judged me, so but still you have learned something, and of course you will learn something from my mistakes. Until then, thank you. Have a good time.